Hello, I'm Miriam Wugmeister from the law firm of Morrison Foerster. I am a partner in our firm and I run the global privacy and data security practice. Today we're going to talk about basics of global privacy and data security. So the first thing you need to think about is, what is personal information? Personal information is any information that identifies an individual or relates to an identifiable individual. It's really anything. It's your name, your email address, your social security number, your address, your credit card number. Any information that identifies an individual or relates to an identifiable information is the information that's covered by the global data protection laws around the world. It relates to employees, it can be customers, it can be consumers, it can be vendors, it can be witnesses, any individual, not just consumers, which is generally what people think about when they think about the data protection laws. There are lots of rules in different countries about what it means to de-identify data. The bottom line is that to make personal information non-personal, to truly de-identify data, is very, very difficult and not something that can be done easily. There are special rules. They're, of course, different in every single country. And so if you want to think about de-identifying data, or you want to know if data have been de-identified, you need to ask very specific questions. Another common misconception about personal information is that information that's public is not considered personal information and therefore not protected. That is generally not true. Just because information is public doesn't mean that it isn't subject to all the same protections under all the data protection laws. Many people think that the laws in Europe are the strictest in the world, and that if they comply with the European data protection laws, they don't have to worry about the laws in any other country. That is simply also not correct. There are over 90 countries that now have data protection laws. The areas where laws are changing the most quickly are in Asia and in Latin America, and some very interesting privacy laws are being adopted in those countries. Laws that are quite different from the European rules, laws that have very strict data security rules, and laws that are really structured quite differently. So with respect to complying with global data protection laws and thinking about privacy from a global perspective, you have to remember that there are laws in Canada, in the US, in Latin America, and in Asia, as well as in the EU. It's really, really easy to lose the forest for the trees when you think about setting up a global data protection program. Because you do have 90 different laws, it's easy to think, oh my God, where do I even begin? The good news is that most data protection laws around the world have common elements. Every data protection law, for example, includes an obligation to tell individuals what information you're collecting, why you're collecting it, and with whom you're sharing it. We call that notice. Under almost every data protection law, you have an obligation to provide individuals with some choice about what information you're collecting and how you're using it. Most data protection laws include a right for individuals to have access to their information and to correct it. If you look on the slide, there are some additional obligations, and I'm going to go into those in a little bit more detail. So in addition to access and correction, which I was just talking about, that means that individuals have the right to call up a company and say, please tell me what information you have about me. And under many countries' laws, you have to tell the individual. You have to give them copies of what information you have about them, even if it's information that the company has created about the individual. It's not just information that the individual gave to the company. And often, under many countries' laws, you have to respond to those requests quickly and accurately. So if you get an access and correction request, it's very important to contact your legal department and figure out the appropriate way to respond. There are very many countries that have rules about limiting disclosures to unaffiliated third parties. That is often something that requires special rules, special notice, sometimes special consent. Every data protection law has some element regarding security. you can't have privacy if you don't have security. If you aren't able to protect the information and ensure that it's only used for appropriate purposes, then you really can't promise anyone that you're protecting their privacy. So just about every privacy law in the world has a security element in it. Many laws have rules about data retention and data disposal. Some have specific rules about how long you can keep information, but just about every law has rules that say if you get rid of information, you need to do it in such a way that it's unreadable, that you really destroy the information completely. Many privacy laws have rules regarding how you have to supervise service providers, what kind of agreements are required, and what kind of due diligence you have to do with respect to the use of supervisors. Many privacy laws, and particularly those in Europe, but not only those in Europe, have limitations on sharing information cross-border. And finally, many countries have rules about either filing affirmative registrations with data protection authorities or appointing data protection officers. So these are the kinds of rules which are essential to any global privacy program. And as I said, the good news is that these elements are common across every privacy law in the world.